Heirs of Yadao versus Heirs of Caletina. GR number 230,784. Respondents averred that they are the grandchildren and surviving heirs of Juan, the registered owner of a parcel of land located in Claveria, Cagayan, with a total area of 1,797 square meters and covered by OCT P479S sometime in 1991. Petitioners occupied the subject land and refused to leave despite their prohibition. The respondents countered that on September 28, 1962, their parents, Josefina and Domingo Yadao, bought Lot 1087 for value and in good faith from Juan's surviving heirs. The sale was covered by a contract written in Locano. Petitioners alleged that the owner's duplicate copy of title was delivered to them and without any dispute from the time their parents bought Lot 1087. They had been in public and continuous possession thereof. Notably, the owner's duplicate of title was delivered to petitioners' predecessors in interest and offered as evidence in court. Petitioners' predecessors in interest occupied and possessed Lot 1087 after its sale on September 28, 1962 until today. Petitioner Ophelia reiterated that her parents bought the subject lot on September 28, 1962, and they have possessed it since that time. The sale was covered by an unnotarized contract and a notarized deed of absolute sale. The trial court ruled in favor of the petitioners, declaring them as absolute owners through succession of Lot 1087 covered by OCT 479S with an area of 1,797 square meters, ruling that there was no evidence to prove the alleged sale of Lot 1087 to the Yadaos. The contract signed by Hospicio, Sr., Jose, William, and Cassiano was not notarized, hence, it was only a private document which was unenforceable. Issue: whether or not the unnotarized deed of sale is valid, effective, and legally binding between contracting parties. Ruling: the court ruled that unnotarized documents do not affect the validity and enforceability of the presumably unregistered and factually unnotarized sale. An unnotarized sale is valid and enforceable against the parties to the sale, as in this case the seller is bound by the sale. All the requisites of a valid contract of sale are present. The fact that the deed of sale was not notarized does not render the agreement null and void and without any effect. The provision of Article 1358 of the Civil Code on the necessity of public documents is only for convenience, and not for validity or enforceability. It added that the absence of which is only necessary to ensure its efficacy. In this case, the court emphasized that although the unnotarized deed of sale is considered a private document, it remains effective as between the parties themselves and also as the third person having no better title, and should be admitted in evidence for the purpose of showing the rights and relations of the contracting parties. Therefore, the deed of sale is not ineffective merely because it is not notarized.